Thank you for joining us today for our Lunch and Learn, the third in our three-part series about venture capital, being presented by Rick Repp, a partner at Witherspoon Kelly. Without any further ado, I would like to turn it over to Rick and get us started. So welcome, Rick.
Thank you, Megan. So this is the third in a three-part series, and thank you to those of you that have been here for all three, and welcome to some new faces that I don't believe were here for the first two. It's good to have you here. For those of you that are new, I have been practicing securities law and corporate law for 17 years here in the Spokane area, and have represented a number of clients in both private placements and registered public offerings. And I also do a fair amount of M&A transactions. And we've got my standard disclaimer here. And just a quick little recap of what we've covered thus far in the presentation. We started off, the first presentation was just looking at the basics of venture capital, and we talked specifically about some of the common terms that you'll see in a term sheet for venture capital. We talked about the difference between true venture capital and angel investing and seed capital, as well as the difference between like a private equity firm and a venture capital firm. And then in the next presentation, we focused on some of the specific documents that typically gets negotiated and drafted and signed in connection with venture capital financing. And one of the things that we addressed, and in part just because of the nature of the businesses in this community and the members in attendance at these presentations, is we pointed out the fact that venture capital, by definition, usually has a very specific term of art with regard to money invested by venture capital firms. But then we also talked about the fact that money that's invested at an early stage of a business is sometimes also referred to venture capital in the broader sense. And so a lot of our presentation for the past two presentations was just focusing on what an entrepreneur needs to know about taking money in from outside investors, because that was a little bit more relevant to our market, where we don't see a whole lot of VC activity. And my presentation today is also going to be in that same vein. I'm going to try to tailor it to what's really relevant to the Spokane market, and just try to be of assistance to entrepreneurs that are taking money from outside investors, whether they're VCs or angels or some other investor. If you do want to see the presentations that were given on the basics and on investment instruments, those are available on the Startup Spokane YouTube channel, and the hashtag is there on the screen. And then today, my presentation is going to focus on sort of three basic areas that I've seen present issues for entrepreneurs and for investors. And I'm going to talk about the importance of maintaining appropriate corporate records once you have outside investors. I'm going to talk about the information rights that those outside investors are entitled to. And then we're also going to talk about some of the control issues that I've seen arise, struggles, battles for control of the company, and just sort of the role that officers and directors and shareholders all play in controlling the direction of the company. So first of all, corporate records. Once you are formed as a corporate entity, and this applies to every entrepreneur who has a Washington State corporation, and it's also true for other states as well. Many of the ideas that I'm going to present that are specific to Washington State are also common in Delaware, for example, but I'm going to focus on specifically what's required under Washington law. But if you have a corporation in Washington, there are certain records that you're required under state law to maintain, and that includes minutes of all your shareholder and board meetings and any action that you take by written consent without a board meeting. It includes all of your accounting records, and it also includes a record of who your shareholders are, both the number of shares they hold and the class of share they hold, and that's required to be maintained in an alphabetical basis. And these are all part of the permanent records that a company is required to keep. And then there's also additional records that are required to be kept at the principal office, which is the headquarters office of the company. And some of those are just your standard corporate documents, your articles of incorporation, your bylaws, shareholder minutes for the past 3 years, your financial statements, any communications that are sent out to shareholders as a whole over the past 3 years, names and addresses of your directors and officers, and an annual report that you are required to file with the Secretary of State. And there's a distinction here that's important to identify between the records that are listed here that are required to be kept at your principal office versus the records that are required to be kept on a permanent basis that don't necessarily have to be at your permanent office. And it comes down to the distinction as to which records a shareholder has a right to inspect and make copies of, and their accessibility to those documents. And I'll talk about that in just a little bit. But let's focus in on financial statements that you're required to maintain. You're required to have at least an annual balance sheet and an annual income statement. Your balance sheet shows you what your current financial condition is as of the year end. Your income statement is showing you what your results of operations actually are. And you're required, again, under Washington state law, to deliver to shareholders those financial records prepared on the same basis that you prepare them for any other purpose. So if you are required by your bank covenants, for example, to prepare your documents using GAAP, then you have to provide your shareholders the financial statements that have been prepared using GAAP, generally accepted accounting practices. If you are required to prepare, have a CPA come in and do an audit or a review of your financial statements, then you're required to provide that same CPA report to your shareholders. And if you don't have a CPA report or review of your statements, then the officers of the company, specifically the president or financial officer of the company, have an obligation to describe to the shareholders the differences from one year to the next and the basis that you used in preparing your accounting statements, so they can understand what the accounting statements are telling them. And that's all important because, again, those are the basic information requirements that you're required to maintain, even if you don't have outside investors. But it becomes much more relevant when you do have outside investors, because now those outside investors are likely to have certain rights to that information. And so now we're going to talk about the information rights that a shareholder is entitled to. And their obligations can arise either under contract and under the state laws, and there are also some federal laws that provide them rights to certain information. So first of all, the contractual information rights may arise in a couple of different fronts. That is often spelled out in the term sheet. One of the things, and we went through the basic term sheet that you see for a VC deal, often it is spelled out what the information rights of the shareholders will be. And if you want to memorialize that in an actual contract, one of the contracts that you typically see is a stockholder rights and participation agreement. So for just in the time since I started this series, I mentioned that at the end of last month, I closed a Series A, a $2.5 million Series A financing for a tech client. And that Series A financing included a stockholder rights participation agreement. And so I'm going to talk a little bit about, use that as an example of what was included there. You could also find a contractual obligation in the stock purchase or subscription agreement to provide certain information to the shareholders. And then it's also, you might if you have a convertible promissory note instead of a stock purchase agreement, you will often see that the information rights that the shareholders are entitled to, or in that case, a debt holder is entitled to, spelled out in the convertible promissory note. So I'm going to talk about each one of these in a little bit more detail. So with regard to the stockholder rights and participation agreement that I just prepared for the Series A financing, the contract specifically went above and beyond the minimum required under state law. So the state law requirement is that the company maintains annual financial statements. And what the shareholders in the Series A financing, the Series A preferred shareholders, specified that they wanted quarterly reports as well. And so in this stockholder rights and participation agreement, it spelled out that they get the annual financial statements within 120 days of year end, and quite frankly, that's something that they are entitled to under state law. But under state law, they have to request it. In this contract, the company has an obligation to prepare and send it to them. And then, in addition to the annual financial statements, there's also an obligation under this contract to send the shareholders quarterly reports. These are unaudited, but it is something that there's an obligation for the company to prepare. Now, it's another important provision that was built into the stockholder rights and participation agreement addresses the confidentiality of that information. And so it spells out that although shareholders in general are entitled to these financial statements, they're not entitled to it if they are in fact a competitor of the company. So it's not unusual to have a situation where an outside investor, or specifically if you are dealing with a professional investment firm like a VC or a family office or a private equity firm, they may own another company that's in the same industry as yours. You might be one company that they own shares in, and then they might own another company that's in the same space and a competitor. So there's a carve out in this contract that specifically says that no, there's certain information that we don't have to disclose if you're actually a competitor, even though you're a shareholder. And then there's also an obligation within the contract for the shareholders to maintain the confidential information and not divulge trade secrets. So that's just a protection for the company that was built into this contract. Another way that you can sometimes see information rights arise on a contractual basis is with a stock purchase or subscription agreement that's used for the actual acquisition of stock in the company. It's very typical that those agreements will have reps and warranties from the company specifying the status of the current capitalization, how many shares are authorized, how many shares are outstanding, if there's any third-party consents that are required to issue the stock to the investors, whether or not there's any outside litigation. Those are the reps and warranties that you make up front at the time that you're selling the stock. There's also often some representation that there's been no material adverse change from the time that you disclosed information to the investors and the time that they actually close on the investment. And then a lot of times it's not unusual to have, specifically if it's a subscription agreement, where there's a time period between the time the investor agrees to potentially invest and the time that the company actually closes on the investment. A lot of times the investors will build in a due diligence review period where they are entitled to review documents of the company's books and records, and their obligation to actually close is contingent upon their satisfactory review of that due diligence. So that's another way that a contractual obligation can create an opportunity for investors to review the company's documents. It's also very typical if you do have a convertible promissory note issued by an investor, that because those convertible notes, the key provision of a convertible promissory note is the idea that it would convert on certain events that happen in the future. And one of those might be a qualified financing of a certain threshold. One of those might be a sale of the company. And it's typical that a convertible promissory note will therefore obligate the company to give notice to the note holders that a qualified financing has occurred or is about to occur, or that a notice of sale is that a sale of the company is pending, and that gives the note holder an opportunity to decide whether or not they want to convert. Typical provision, or there might be an automatic conversion upon the sale of the company, and the note holder wants to know about that in advance. And it's also, keep in mind that if you're up until the time that convertible promissory note actually converts into equity, the note holder is not a shareholder of the company, and therefore, unless they spell out in the contractual terms of that promissory note, they don't necessarily have the rights of shareholders, and not even under state law, because if they're not a shareholder, they're not entitled under state law to inspect those records and to receive the report. So a lot of times, an investor that's investing via a convertible promissory note will specify that they are entitled to the same information rights as the shareholders, and that's the way that they ensure that they get the information that they want to know about the company. And so now, the concept that there are specific information rights that the shareholder has a right to access, that is granted under state law. So we talked about the fact that under state law, there's records that the company has to keep them out if there's not a contractual obligation to do so, but shareholders may request the year-end financials. The shareholders are also entitled to prior notice of meetings, both special meetings and annual meetings of the shareholders, and then they have specific inspection rights that we're going to talk about. So first of all, it's something to keep in mind about notice of meetings. You often have an annual meeting. Under state law, you typically, and under your bylaws and articles, you typically have an annual meeting where the directors are elected and other material transactions take place. But if you're going to be doing something like amending your articles so that you can issue additional shares of preferred stock, for example, is a typical transaction that requires amendment of your articles, then that you need to give earlier notice. You have to give 20 days notice for a special meeting where something like amendment of the articles or perhaps sale of the company are going to be taking place. And if it is a special meeting, under state law, there's an obligation to provide a description of the purpose of the special meeting, which is not something you necessarily have to do for an annual meeting, but you definitely do for a special meeting. So you have to, if you're going to be amending your articles to issue preferred stock, for example, you need to let the shareholders know that. And then in terms of the shareholders' ability to look at the records that the company maintains and even make copies of those records, there's that distinction between I pointed out there was a slide that talked about the information that has to be permanently maintained by a company versus the information that must be maintained at the company's principal office. And that with 5 business days notice, any shareholder has the right to inspect and copy any of the records that are required to be kept at the principal office. So that includes the articles and the bylaws and the minutes of shareholder meetings. And then there's a higher standard for some of those permanent records. Oh, it looks like someone's trying to get in the door here. So in the permanent records is specifically the board minutes and the accounting records and the shareholders' ownership records. Those are the items that are required to be permanently kept, but not necessarily the principal office. So, for example, accounting records from 5 years ago, those might be kept off-site. So if a shareholder has, there's a little bit of a restriction on shareholders' ability to access those records. They can automatically look at the articles and the bylaws and the shareholder minutes, but if they want to look at the board minutes or they want to look at the accounting records, then they have to be able to tell the company that there's a good faith and proper purpose for accessing those records. They have to describe that purpose with reasonable particularity, and then the records that they're requesting actually have to be related to that specific purpose. And so sometimes if a shareholder is just trying to be difficult or has ulterior motives that are not necessarily in the best interest of the company can actually resist turning over those records. But if it's sort of the standard situation where the company, the investor that's made an investment in the company and wants to have a full understanding of where did my investment dollars go, then they generally have a right to get that information. Now, something that a lot of entrepreneurs don't think of, at the outset is, there are some federal laws that also protect shareholders with regard to the information they're entitled to receive. And one of the things that you sort of have to keep on the radar as you add additional shareholders and take on additional investment is there are certain thresholds where you become a public company even if you didn't want to be a public company. So if you trip across these shareholder thresholds and you have over $10 million of assets, then you are obligated under federal law to become a SEC reporting company. And this number has actually been increased significantly under the Jobs Act. 2014, that threshold was raised because entrepreneurial companies did not want to be public companies subject to the SEC reporting rules because of the financial expense associated with that. And one of the big driving reasons why these thresholds were increased is because Facebook tripped across the threshold. That's the real reason Facebook went public, not because they wanted to, but because they had issued so many shares to so many different shareholders over the years, including employees, that they had so many shareholders that they became obligated to go public, even though some of their shareholders would have preferred that they stay private, at least until a later date. So anyway, so that's a little trivia on even a big company like Facebook can get forced to become a public reporting company. One of the other federal reporting requirements that applies to even to startup entrepreneurs that are raising money, if you're using a Reg D 506 offering, which is an exempt offering. Oh, I'm sorry, is there a question back here?
Yeah, I was just wondering about the 10 million in assets.
Yes.
If you raise money, doesn't that become an asset? So if Facebook raised $1 billion before they ever went public, are you saying that they should have gone public at 10 million?
Well, so it's not just, it's $10 million assets and one of these thresholds. So it's both. It's both criteria. So I'm sorry that's not clear in the slide, but yeah, it's you have to have $10 million of assets and you have to have a certain threshold of shareholders. So back to Form D. So 90% of the private placements are done with a Reg D 506 exemption, which prevents you from having to register your offering with the SEC. And I'm trying to avoid getting into a securities law presentation here, but I just want to highlight that for an entrepreneur, that one of the ways you preserve the safe harbor under 506 is by filing a Form D within 15 days of raising money pursuant to that exemption. And that form will disclose to the public how much money you raised and also the use of proceeds, and if there's any compensation from that offering going to officers and directors or anyone else that helped you raise the money. So again, just sort of on the checklist of federal requirements that offers disclosure. And that's something that quite frankly, it may be of benefit to some of your shareholders, because if the shareholders have not negotiated in their investment documents any type of protection against dilution or a right to participate in future offerings, maybe they just purchased common stock in a friends and family round, they may or may not have any way of knowing whether or not you're raising additional money. Because you don't necessarily have to, there's not some proactive obligation to tell them that you're going out to raise more money. So one of the only ways that they might find out as a minority shareholder is to pay attention to the filings that are made on behalf of the company. So that's one way that federal law protects shareholders. And then another important rule that's easy to overlook with privately held companies is, if the stock that has been sold to private investors, if those private investors want to turn around and ever resell that stock, they need to find an exemption to do so. And Rule 144 is the primary rule that's used under the SEC rules for a shareholder to turn around and resell their stock. And in order for them to be able to, and maybe be a little bit more precise here. So usually it's the shareholders taking advantage of an exemption that's called 4.1, or what's called the 4.1.5 exemption, and that's been modified in recent years. But the idea is that in order for a shareholder to turn around and sell stock in a privately held company to someone else that doesn't necessarily know anything about the company, and the company's not public reporting, the idea is that the company is obligated to put certain information out there and available to the public, and it's typically done with their website. So if an officer or a director wants to turn around and resell stock that they purchased from a privately held company, they usually need to do so pursuant to Rule 144, but that's gonna be difficult for them to avail themselves of the protections of that rule if the company doesn't have information about its business and its services and the facilities that it owns and who its officers and directors are, and also 2 years worth of financials posted on its website, because otherwise how else are they going to get that information? So sometimes in privately held transactions, a lot of times, if you have a sophisticated investor, they will be asking for this information before they invest. But again, I'm just trying to give you a heads up that this is the type of information that you need as an entrepreneur. You need to be prepared to provide to the public if you're going to be taking an outside investment. All right, so then let's talk about some of the control issues that you often see after you take in outside investors, and just sort of recap the role that management, the board of directors, and shareholders have with regard to running a company. So it's typically management's job to run the business on a daily basis, making the daily operating decisions, entering into contracts for sales and for purchasing supplies, et cetera. That's delegated by the board to the CEO, and the CEO hires the employees that he needs in order to get the job done. Now, and it is the board of directors who's responsible for hiring the CEO. That's usually the one and only employee that they hire, and then they set the policy for the company with regard to, what are the goals and what are the directives to the CEO of, do we want to grow the company in this direction? Do we want to acquire these assets? And usually it's, we're talking material changes in the direction that the company's going. That'll be set by the board of directors. And then the shareholders typically don't have a voice in those individual decisions. Their way of controlling the company is by electing the directors. And the idea is that they elect the directors to the board, and the board as a whole then selects and oversees the CEO, and the CEO charts the path for the company. And so you get some interesting dynamics going on. One of the things that is sort of important with regard to making sure that management is doing what the board wants, and one of the ways that you sort of control and motivate the behavior of management is with regard to an employment agreement. And a lot of startups do not have employment agreements. It's very typical, since this is Washington is an at-will employment state. Most employees are going to be at-will employees, which means you can fire them anytime you want for any reason without cause. But if you bring in a sophisticated, experienced CEO that has a track record of running other businesses because your company's at that point in time, a lot of times a sophisticated CEO will demand an employment agreement. And that employment agreement will provide some obligations to pay that individual for a specified term. And typically what you see is a one-year term on an employment agreement. And then what happens is if the board decides that they need to terminate that CEO 6 months into the relationship, without due cause, they just decide that it's not working out and they don't like him and they don't like his vision, then a lot of times that CEO will be entitled to the remaining payment obligations for the remainder of his term. So if it's a one-year contract and they terminate him at 6 months, then he's still entitled to a 6-month payment. And so what the end result is, you sometimes see companies that will wait out or try to work with a CEO until his term is up, or else they'll look for cause to fire him. And then so then there's usually a provision spelled out in the employment agreement that specifies what the definition of what cause is and when the employer can terminate that employee. And so that's a really important provision and really important decision for the company to make is, okay, are we going to offer term employment agreements? There's pros and cons to doing so, but that's an important way to both control and motivate your CEO. Another way that management is controlled by the board and motivated is through the vesting schedule. That's if you're offering equity incentives to those employees, then the vesting criteria that you use plays a big part in determining your ability to control the behavior of the employees. So in Silicon Valley, and I think we talked about this a little bit in one of my earlier presentations when we talked about vesting, it's not unusual down the Silicon Valley to have either monthly or quarterly vesting on equity incentives. And in part, that's because of the job market down there. There's a lot more fluidity amongst the employees. They're hopping from company to company, and there's a demand for the good employees, and so they're in a negotiating position where they can basically demand that they get monthly vesting, and the idea is that they don't want to have to wait out an entire year if they don't like the job or another opportunity comes along. They want to be able to vest if they're 8 months into the year, they want 8 months worth of the stock. And that works down there. Up here in this market, what is much more typically seen is annual vesting, and that's something that I recommend for all my corporate clients is that they provide annual vesting. And so that in that situation, if the employee can't hack it for a year, then and they leave before a year is up, then the company does not, they lose any of the unvested stock. And I just had a situation where one of my startup clients, hired an upper level executive that came in with lots of razzle dazzle, and they were all very excited to issue him a whole bunch of stock options and stock incentives. And, but the relationship soured, 3 months down the road, and they realized that the founders of the company and the new executive did not see eye to eye, and so they were glad to get rid of him, and they were really glad that it was an annual vesting schedule and he wasn't entitled to keep any of the stock, because otherwise they would have been stuck with a shareholder that they didn't even get along with. So annual vesting is good from the company perspective, monthly vesting is good from an employee perspective. There's another question back here.
What happens if you have, say you're in year 2, the employee's vested, you're doing this annual vesting, and in month 11, there's a change of control of the company. Does the employee lose the entire second year vesting?
Well, usually, typically what you see is a change in control provision in the either the equity incentive plan that talks about what happens to equity upon a change of control, and then also in the if it's a stock option agreement or it's a restricted stock agreement, that specific agreement will almost always have a provision on what happens upon a change of control, and that's usually addressed. And how it's usually addressed is with it usually vests upon a change of control. So any unvested equity vests. Now there are sometimes you will sometimes have a double trigger, and that's not necessarily as friendly to the employee, but a lot of times if you have sophisticated VCs coming in and you're issuing equity after you have some sophisticated investors as part of your company, they will usually demand a double trigger vesting condition on a change of control. So they will require that let's say a restricted stock agreement, for example, include not only has there been a change of control, but the employee has been terminated. So that's two different triggers: change of control, employee no longer has a job, and so before that it vests. But in a lot of the agreements that I prepare, I just have a single trigger. If there's a change of control, the options vest, or the restricted stock vests, is the way and it's almost always addressed in the grant agreements. Now, another interesting situation that I've been dealing with on behalf of a client recently is clawback and forfeiture provisions. Now, a properly drafted equity incentive plan will typically have some provision that talks about, well, what happens if the employee is terminated for cause, and to be terminated for cause, there's because they violated company rules, or they violated accounting rules, or in this particular case, the situation I was just dealing with, it was a sexual harassment situation. So the upper level executive needed to be removed from the company. He caught wind of the fact that his departure was imminent, and then he, quote unquote, retired. And because the equity incentive plan and the incentive documents that they were using were drafted before our law firm was involved, they were poorly written, and lo and behold, he was able to claim that all of his unvested stock was therefore vested simply because he gave notice of retirement. And he was very prudent to retire as soon as he knew that he was going to be canned. And so it became a race to the race of documents. And so here was a situation where he knew that he was going to get busted for sexual harassment, and so he was still able to claim full vesting in his equity. The solution to that, if you're the company, is to make sure that you have a clawback forfeiture provision that even if the stock incentives have vested, if the employee is terminated for cause, then you can require those, even though it's been vested, you can require forfeiture and voiding that stock. And so that's an important provision to have in today's world where you can't always trust your employees to behave themselves. And then another important way of controlling your employees and an issue that typically comes up is, what are the change of control provisions if there is a sale of the company? And I've seen, so one of the transactions that I'm working on right now, the press release went out this morning. I'm working on the INB acquisition. First Interstate Bank's acquiring Inland Northwest Bank. It's a $165 million deal, and that's going to close tomorrow. And in that situation, again, you have a larger company, established company, obviously. There were change in control provisions within the employment agreements of the executive management, so that they have an incentive to help the company see the company through all the way through a potential acquisition, and to stick around and help integrate the acquisition. And then there are certain employees that, although they weren't executives and subject to an employment agreement with a term, but they were still deemed to be valuable employees that the company wanted to stick around, they had just a change of control agreement. And so again, a lot of times if you're in an industry such as banking or specifically in the tech world, where there is a lot of acquisition, that's usually the exit that companies take, it's not unusual for your most valuable employees to want some type of change in control protection so that they stick around when they see that when the company might be up for sale. Because otherwise, the additional work that is required of an employee to make a change of control successful and follow through, sometimes if they don't have any incentive, they're not motivated with any incentives to stick around, they might just say, well, this is a good time to find another job, and then you're left in the lurch as you're trying to complete the sale of your company. So change of control provisions are an important way of controlling your management. Okay, so and then again, when it comes to the way that you sometimes see struggles for control of the company with regard at the board level, the important documents include your articles of incorporation and your bylaws. Your articles of incorporation will specify how your common stock votes, how your preferred stock votes, and a little war story here. In a situation that I saw within the past couple years, I had a tech company where the outside investors wanted to oust one of the top level executives, and I'm choosing my words carefully here for client confidentiality, and so they successfully ousted one of the founders, who was an executive of the company, but what they didn't realize is that the other founder, who not only held a majority of the common stock, but also happened to hold a voting agreement with regard to his co-founder's common stock, was able to vote the common stock together with the preferred stock. And so it wasn't just the preferred stock that was able to remove members of the board. Now, so the outside investors had specific board seats that they were entitled to elect on the board. But the common stock and the preferred stock voting together was allowed under the articles and under the stock purchase agreements to remove any director and under the bylaws. So what happened was the outside investors removed one of the founding executives, and then the other co-founder removed those directors. And the preferred stock outside investors still had a right to fill those board seats, with up to 2 of the board seats, but that didn't change the fact that the entire board had been removed, and then it became a struggle for control over who got to replace those new board members. And so this is I mean, as a corporate lawyer, this is where things start to get really interesting. When you have a struggle for control of the company, and you have outside investors, and you have founders that don't see eye to eye, how the common stock votes and whether or not it votes with the preferred stock becomes really important. And then another thing, another document that all of a sudden that people just ignore until people don't see eye to eye are the bylaws. And so the bylaws will specify the size of your board. A lot of times that'll give a range, like your board can be 3 to 5 members, or it can be 3 to 7 members. And the reason why that's really important is if there's a dispute at the board level or amongst the shareholders with regard to what decision the board should be making, if you can increase the size of the board, then you can change the majority representation on the board. So if you go from a 3-person board to a 7-person board, who has the ability to appoint those other 4 seats? And how do they get selected? You can change the course of the company if you can change the membership of the board. And so that's why the number of board seats that are specified in the bylaws, as well as how many of those are filled and how many of those remain to be filled, becomes really important. And typically you can't just increase the size of the board or change the bylaws without approval from the shareholders. So if you don't have a majority of the shareholders lined up to approve a change to the bylaws, then you're stuck with the size of the board, or maybe you don't view that as being stuck, maybe you view that as exactly the way you want it, depending on your position in the argument. Another thing what the bylaws can specify is whether or not there's cumulative or non-cumulative voting, and that's this concept that either you can take all the votes that you have and direct them all to just one individual board candidate, so that you can ensure that you have at least one person on the board that represents your views, or else you have to vote your shares for each one of the seats, and that's something that you sometimes see how control of the board is is determined. And then another interesting example that I just dealt with this, again, within the past month or two here, is a voting agreement that I had a client use a voting agreement to create to amend the existing voting agreement to create some board seats for a specific investor. So the voting agreement that all the Series A investors had agreed to had specified that a majority of the Series A stockholders had the right to force the other shareholders. It had a drag-along provision where if the majority approved the action, then the other stockholders had to go along with it. And if they didn't vote in favor of the action approved by the majority, then there was a proxy provision that basically would vote the minority shares in favor of whatever the majority wanted to do. And so that was used to amend the voting agreement. So they actually had a majority of the stockholders that agreed to amend the voting agreement, and then that voting agreement specified that there were going to be 2 designated board seats that all stockholders, if the majority approved those 2 seats to be designated for some specific investors that were coming in to the company, then all the stockholders basically would have their votes dragged along by the majority in favor of those designated board seats. And that was one of the ways that you could ensure that the investors, the new investors negotiated that provision as a way to ensure that they had their voice and their presence on the board. Because again, it's the board that sort of drives the direction of the company. And so, and then this sort of bleeds into, well, how do the shareholders control the company, and what are some of the issues you see when there's a dispute for control amongst the shareholders? A voting agreement is really the primary document that becomes really important in terms of trying to control the direction. Sometimes you'll see a voting agreement where it requires 2/3 of the shareholders to approve an action before they can drag along the other shareholders. Sometimes it's a majority, as in the case that I just cited, and those drag-along rights become really powerful, and they're really important at points in time when there's a disagreement amongst the shareholders as to whether or not the company should be sold. A lot of times that's the exit for an investor, and the entrenched management may not want to see the company go away, because that's their job, that's their baby, that's what they've invested all their time and effort into, is to growing this company, and they're not ready to retire. They don't want to go on and do something else. So sometime, and I've got situations where I represent entrepreneurs and I represent investors, and the investors are frustrated with what they call a zombie company, because the company is not growing as fast as they would like, and the company is not willing to sell itself, and so and they don't have the ability to remove the CEO, who's also the founder and controls enough a majority of the common stock. And so there's sort of in this situation where if they can't get enough votes in their camp based upon what they own, or they can't force other shareholders to vote along with them, then they may miss out on this opportunity to sell the company. And so a lot of times what you'll see, because sophisticated investors don't want to be in that situation, they'll typically negotiate some form of drag-along rights that say, even though we need 2/3 approval of the shareholders to sell this company, if we can at least round up a majority, then with a voting agreement that has drag-along rights, the majority can say, we approve this sale, and therefore the minority has to vote along with it, and then the company gets sold. And again, this concept of supermajority is usually spelled out in the articles and in the bylaws. Another interesting situation that I just had, that sort of an example of shareholders sort of controlling the company. I've worked on a couple of reverse stock splits where the company it's a feature of state law that a company is generally able to issue to amend its articles of incorporation in such fashion that any shareholder that doesn't have a certain number of shares gets cashed out. And so and so long as the company pays fair market value, and so there's usually a third-party company that comes in and does a valuation of the company and the shares. As long as the shareholders are paid fair market value, it's a way for majority shareholders to cash out minority shareholders that have either been a problem or they no longer want to have as part of the business. And so again, that's one of those ways that you sometimes see minority shareholders and majority shareholders sort of struggling for control of the company. And those were the sort of the issues that I wanted to discuss today with regard to some of the things that you see and that you deal with after you've taken outside investors and you're dealing with shareholders. And I'm happy to answer any questions. I hope this was helpful. Question back here in the back?